Good afternoon to you all. I would like to start by thanking the organizers of this Congress for their kind invitation. It is a real honor for me to participate in it. I would also like to apologize for not being able to accompany you personally in Salonika, but for last-minute reasons, it has been impossible for me to do so. Well, my speech is divided on several points, and the first one is about the legal framework in Spanish system. The Spanish Constitution recognizes the right of asylum in Article 13.4, leaving it to the law to specify its implementation. In fact, the granting of the right of asylum has always been a symbol of national sovereignty. In the Spanish international protection system, a comprehensive reception and integration system is developed and managed for asylum seekers, refugees, stateless persons, individuals under temporary protection status, and other forms of subsidiary protection. The regulation of this progress is found in the Law 12 of 2009, regulating the right to asylum and subsidiary protection, what we call the Asylum Law, and the Royal Decree 203 of 1995, approving the regulation for the application of Law 5 of 1984, regulating the right to asylum and refugee status. As their date indicates, the asylum regulation do not correspond to asylum law, but to the previous law. However, it is still in force because despite the fact that the third final provision of the Asylum Law of 2009 established a 6-month period to develop the corresponding regulation to this law, it has not been carried out yet. 13 years later, without a development regulation in sight, the doctrine and even the Ombudsman, the Spanish Ombudsman, identify various difficulties in applying the asylum law. The Spanish asylum law established that asylum is the right of persons who have fled their country of origin or stateless person who have left their habitual place of residence to protection, reception, and assistance. And it defines a refugee in the same way as the Geneva Convention do, adding the grounds of gender or sexual orientation. On the other hand, the right is granted to those persons who, even if they do not meet the above-mentioned requirements, present reasons that would indicate a risk of serious harm if they return to their country. In particular, serious harm giving rise to subsidiary protection is constituted by death penalty or the risk or physical execution, torture and inhuman or degrading treatment in the applicant's country of origin, and serious threats to the life or integrity of civilians caused by indiscriminate violence in situations of international or internal conflict. The second point I want to touch, to talk about, is the procedures in Spanish system. In the Spanish territory, request for protection might be made upon entry at the border or after having been in Spain for some time. Both come with their own challenges and their own controversies. The asylum application might be submitted in different places, for example, at the border, at the airport, at the immigrant detention center, among others, although it is more common to do so in the first month after entering Spain and following the procedure established in Articles 17 to 29 of the Asylum Law. However, there are certain limitations to this, such as the state competence requirement. In principle, Spain is only competent to process a protection request if it is the first state in which the person has arrived fleeing their country. Nevertheless, these limitations, as well as the vast majority of grounds for inadmissibility, seldom results in the denial of a request. This is due to the fact that the Asylum and Refugee Office, which is in charge of all matters related to asylum, is incapable of denying petitions within the 1 month period established by law. Furthermore, there is a sort of tacit approval. It can be considered that this mechanism operates almost always because the Asylum and Refugee Office does not seem to have the necessary resources to reject applications within the established deadline due to the high number of asylum requests. The Ombudsman, Spanish Ombudsman, has raised serious concern about this, stating that the high number of admissions by default could result in addition to a danger to public safety, a deficient care assistance to international protection seekers. For example, in 2020, we have in Spain more than 100,000 requests, and only 6 of this number were denied. The first step in the asylum process involves expressing the intention to seek asylum to the police. At this stage, any deportation proceedings are suspended, but the applicant remains in an irregular status, and especially it is not allowed to work. A preliminary date is set for an interview, which typically takes place several months later. During this interview, the applicant provides their testimony and formally requests asylum. It should also be noted that the Home Minister, what we call in Spain the Ministerio del Interior, at the proposal of the Asylum and Refugee Office, may, by means of reasoned decision, refuse to process applications for lack of competence to examine the applications or the lack of requirements. An opinion that has been heavily criticized by some authors as implying a wide margin of discretion of the administration. In the second phase, the formal asylum request is made after the interview, and legal assistance may be requested to ensure that the process is carried out correctly. After 6 months, applicants are automatically authorized to work without any additional procedures unless their application has been denied or deemed inadmissible. The asylum law established two clear grounds for refusal. Specifically, asylum will be refused to persons who constitute, for well-founded reasons, a danger to the security of Spain, as well as to those who, having been convicted for serious crimes, constitute a threat to our community. The non-admission or rejection of applications for international protection shall determine, as appropriate, the return refoulement, expulsion, compulsory departure from Spain territory, or transfer to the territory of the state responsible for examining the asylum application of the person who has applied for asylum, unless the person concerned meets the requirement to remain in Spain in a situation of stay or residence, or their stay of residence in Spain is authorized for humanitarian reasons determined by the regulations in force. We will see a case now about the people from Venezuela in Spain. The third point I want to talk about is the realities and main barriers, the burdens, to accessing refugee status and protection. Most asylum seekers have their request finally denied, especially those from nationalities that seek asylum the most in Spain, such as Colombian people or Venezuelan people. Once the request is denied, the applicant is not authorized to work unless they file an administrative or judicial appeal. It is worth noting that applying for asylum is not incompatible with any other authorization or request, and individuals can even apply for asylum while being in an irregular situation. In the case of Venezuela, their asylum request may be denied, but they can be granted a humanitarian residency and work authorization. On the other hand, it should be borne in mind that when an applicant receives a notification of refusal of international protection, he or she has the option of lodging an appeal, either an appeal for reconsideration with the first month and or a contentious administrative appeal within 2 months of receiving the notification. I would like to talk about the alternatives for obtaining legal residence. I think it's a very interesting point. Most refugees seeking asylum have, as I have said, their status denied and need to find alternative ways to obtain legal residence. The labor integration route has become increasingly popular in recent years due to the evolving of our Spanish cause law. Article 124 of the Immigration Acts outlines the provisions for this route, stating that foreigners who have continuously resided in Spain for a minimum of 2 years may obtain authorization through labor integration, provided that they do not have criminal record in Spain or in the country of origin, or in the country or countries they have resided for last 5 years, and can demonstrate the existence of employment relationship lasting no less than 6 months. To prove the employment relationship and its duration, the applicant must present a court order recognizing it or an administrative resolution confirming an infraction report from the Labour and Social Security Inspection that verifies it. Until March 2021, it was interpreted that only those who have been working without authorization will, in an irregular administrative situation, could access to the labor integration route. However, the Spanish Supreme Court settled this debate in a recent judgment 1184 of 2022, considering that the employment relationship and its duration could be proven through any legally valid means of evidence. This means that anyone who had held a residence and work permit in the past, but had lost it, could obtain this permit if they had worked for 6 months required by law prior to the application. The procedure for labor integration is regulated in Article 128 of the Immigration Regulations, and the deadline for the resolution is set out in additional provision 12. If there is no clear resolution and notification within the 3 months deadline, these applications might be considered denied, so the silence is negative, and applicants may appeal this decision through a motion for reconsideration or a contentious administrative appeal. Additionally, following the reform of the immigration regulation, there is now an authorization for collaboration with administrative authorities, which replaces the previous labor-biased residency for those who have worked in an irregular situation without a work permit but meet the same requirements as for the labor-based residency. Finally, I would like to speak about the role of the ombudsman, the Spanish ombudsman, on this matter. It is worth making a very brief reference to another issue, namely the role of the Spanish ombudsman in this matter. To do so, we must begin by recalling that in the pursuit of making citizen rights and the very notion of good administration real and effective, other types of instruments have been emerging alongside judicial control, whose functions includes a predominant role as a guarantors of the new rights. Of this, the ombudsman, le médiateur, el defensor del pueblo, deserves a very special mention. In the end, the European Ombudsman, Emilio O'Reilly, has already said, and I quote, "Democracy works on the basis of trust, but also on a strong system of check and balance. Citizens need to know that oversight bodies work independently and with the public interest as their only interest. We have seen across the world, and in parts of the EU itself, the damage caused to democracy when power is exercised in defiance of that independent oversight. The EU can and should show leadership through its strong championship of independent oversight and excellence in public administration." It's the end of the quote. Well, I would simply like to point out that foreigners, regardless their documentary situation in Spain or even their age, can turn to the Spanish ombudsman if they consider that Spanish administration has violated their rights or they have suffered delays in the processing of nationality by residence applications. In addition, the ombudsman make announced visit to the detention centers for foreigners, and the persons held that there can make personal interviews if they wish. He also supervised the action of Spanish consular abroads. Among its studies and monographic reports, both the 2021 and 2016 reports refers to that issue. I would like to point especially the 2021 edition that was dedicated to migration in the Canary Islands, because Spain's geographical localization, bordering northern Western Africa, significant the conditions of this community of Spain, the Canary Islands. The 2016 study was dedicated precisely to asylum in Spain. And that's all. I would like to thank you all for the attention, and I'm sorry not to be there, but I hope that if you have any kind of question, I can try to answer it by email. Thank you very much for everything.